I was standing at my kitchen window with my morning coffee when I watched the HOA's snowplow driver absolutely demolish the deck stairs. I had spent 3 weekends building last fall, and the worst part was seeing him glance back, clearly notice what he had done, and just keep driving like nothing happened. My name is Peter Rollins, and I had lived in the Meadowbrook Heights development in Naperville, Illinois, for exactly 18 months. The subdivision was one of those newer communities where every house looked almost identical, painted in approved shades of beige, gray, or cream, with manicured lawns and strict rules about everything from mailbox placement to the height of your grass. When my wife Sarah and I first moved in, we thought the HOA would be a minor inconvenience at worst. We were so wrong. The morning of January 15th started like any other winter day in the Chicago suburbs. We had gotten about 8 inches of snow overnight, which was pretty standard for mid-January. I was up early because I worked from home as a software developer, and I like to get a head start before my first meetings began at 9. The sun was just starting to come up, casting that pale winter light across the white landscape. I had installed a security camera system around my property about 6 months earlier, not because of any particular incident, but because my homeowner's insurance gave me a decent discount for having one. The cameras covered my front yard, driveway, and the back deck area. I could access the feeds from my phone or computer, and they recorded continuously to a cloud storage service. That decision would turn out to be the smartest thing I had ever done. As I stood there watching, I saw the large orange plow truck making its way down our street. The HOA contracted with a local company called Superior Snow Services for winter maintenance. They were supposed to clear the main roads and the driveways up to where they met the street. The driver that morning was going way too fast for a residential area, especially one covered in fresh snow. I watched as the truck approached my house. My driveway was situated on a slight curve in the road, and my property had a corner lot, which meant I had a longer frontage than most of my neighbors. The deck I had built extended from the back of my house, but wrapped around the side, with stairs leading down to a stone pathway that connected to my driveway. The stairs were beautiful, constructed from pressure-treated lumber with a handrail that met all the local building codes. I had even gotten them inspected and approved by the village, though the HOA had given me grief about the stain color not being on their approved list. The plow came barreling around that curve, and the driver had his blade angled wrong. Instead of pushing the snow onto the parkway, he had it angled in a way that sent a massive wave of snow, ice, and whatever else was on the road directly toward my property. The force was incredible. I watched in horror as this wall of frozen debris slammed into my deck stairs with a sound I could hear even through my double-paned windows. The impact was devastating. The bottom 3 steps completely shattered, splintering into pieces. The 4th step cracked down the middle. The handrail post snapped like a toothpick. Chunks of wood went flying across my yard. It looked like someone had taken a battering ram to the structure. The driver definitely saw it happen. I watched him turn his head, look directly at the destruction, and then just accelerate down the street without stopping. I stood there for a moment, completely stunned. Then I grabbed my phone and immediately started checking my camera feeds. Sure enough, all 3 angles had captured the incident perfectly. The timestamps, the license plate of the truck, the company logo, everything was crystal clear. I threw on my winter coat and boots and rushed outside. The damage was even worse up close. The stairs I had spent hours building, sanding, and finishing were destroyed. Jagged pieces of lumber stuck up at odd angles. The railing hung loosely, dangerous, and unstable. The whole structure would need to be completely rebuilt. I estimated the damage at around $3,000 in materials alone, not counting the labor. I took photos from every angle with my phone, making sure to capture the pile of snow and ice that was still sitting at the base of the destroyed stairs, showing exactly what had happened. Then I went back inside and downloaded the video footage from all 3 cameras. I saved multiple copies to different locations, including emailing them to myself and uploading them to 3 different cloud storage services. I had a feeling I was going to need that evidence. My first call was to the HOA office. Meadowbrook Heights had a management company that handled day-to-day operations, and there was a property manager named Deborah Finch who was supposed to handle resident concerns. I had dealt with her before over various minor issues, and she had always been cold and dismissive, acting like every request was a massive imposition. The phone rang 4 times before someone picked up. Meadowbrook Heights Community Association. This is Deborah. Hi Deborah, this is Peter Rollins at 247 Wyndham Court. I need to report an incident that just happened. The HOA's Plow driver just destroyed my deck stairs. I watched it happen and I have video footage. There was a pause. I am sorry, can you repeat that? I explained again, trying to keep my voice calm and professional. The snowplow that the HOA contracts with just plowed into my deck stairs and completely destroyed them. The driver saw what happened and drove away without stopping. I have the entire thing on my security cameras. Mr. Rollins, I am sure you are mistaken. Our plow drivers are professionals. They would not damage resident property. I literally watched it happen from my kitchen window. I have video evidence from 3 different angles. Well, if there is damage to your property, that would be between you and your homeowner's insurance. The HOA is not responsible for snow removal damage. I felt my jaw clench. Your contractor destroyed my property. Of course the HOA is responsible. Mr. Rollins, I suggest you file a claim with your insurance company. Now, if there is nothing else, I have other calls to take. I want to speak to someone else. Who is the board president? The board does not take calls from residents. You can submit your complaint in writing to the board, and they will address it at the next monthly meeting. When is the next meeting? February 12th. That is almost a month away. My stairs are destroyed right now. That is the next scheduled meeting. You are welcome to submit your complaint in writing, and it will be added to the agenda. Good day, Mr. Rollins. She hung up before I could respond. I stood there staring at my phone, feeling my blood pressure rising. This was exactly the kind of bureaucratic nonsense I had come to expect from the HOA, but I had not anticipated them just flat out denying responsibility when I had video proof. My next call was to Superior Snow Services. A man answered on the second ring. Superior Snow, this is Mike. Hi, I live in Meadowbrook Heights and one of your plow drivers just destroyed my deck stairs. I need to know what your insurance information is and how to file a claim. Whoa, slow down. What happened? I explained the situation again. Mike listened, then said, hang on, let me check the schedule. Who is your HOA contact? Deborah Finch at the management company. Right, okay. Listen, if there was an incident, you need to go through your HOA. They are our client, not you individually. They will need to file the claim with us if they determine our driver was at fault. I have video footage showing your driver plowing directly into my stairs. Then you should give that to your HOA and let them handle it. I cannot take a direct claim from you, sorry. Our contract is with the association. This was getting more frustrating by the minute. So you are saying I need to go through the HOA, but the HOA is saying they are not responsible. I do not know what to tell you, buddy. That is between you and your HOA. We just do what they tell us to do." I hung up and sat down at my kitchen table. Sarah came downstairs, still in her pajamas. She worked as a nurse at Edward Hospital and had the day off. "I heard you on the phone. What happened?" I explained the whole situation. She walked over to the window and looked out at the destroyed stairs. "Oh my God, Peter, those stairs are completely ruined." "I know. And the HOA is already trying to deny responsibility." Sarah was quiet for a moment, then said, "You have the video footage, right? They cannot deny it if you have proof." "You would think so. But Deborah basically told me to pound sand and file with my insurance." "What about the police?" "Hit and run. The driver left the scene of an accident." I thought about that. I do not know if property damage counts the same way a vehicle accident would, but it is worth a try. I called the Naperville Police Department's non-emergency line and explained the situation. The dispatcher was polite but not particularly hopeful. "Sir, this sounds like a civil matter. Since there are no injuries and it was not a traffic accident, we probably would not send an officer out for a report. But the driver damaged my property and fled." "I understand your frustration. But unless there is evidence of criminal intent or significant public safety concerns, these types of property disputes are typically handled through civil court or insurance claims. You are welcome to come down to the station and file a report if you want documentation, but I want to be upfront that it probably would not lead to any criminal charges." I thanked her and hung up. Sarah was watching me with concern. "What did they say?" "Basically that it is a civil matter. But I think I will go file a report anyway, just to have it on record." I spent the next hour at the police station filling out paperwork. The officer who took my report was sympathetic, but confirmed what the dispatcher had said. "Look, you have video evidence, which is great. That is going to be your best asset if this goes to court. But from a criminal standpoint, there is not much we can do here. The plow driver was not acting with criminal intent, and the damage, while significant, does not rise to the level of criminal mischief under state law. This is really a case for civil court or an insurance claim. The HOA is denying responsibility." He shrugged. "Then you might need to sue them. I know that is not what you want to hear, but that is probably your best option. You have documentation, you have video evidence, you have a clear case." Small claims court handles disputes up to $10,000 in Illinois. Your filing fee would be about $75, and you would not need a lawyer for that. I left the station with my report number and a growing sense that this was going to be a much bigger hassle than it should have been. Back at home, I sat down and composed a formal written complaint to the HOA board. I described the incident in detail, noted that I had video evidence and a police report number, and demanded that they accept responsibility and arrange for repairs through their insurance within 7 business days. I sent the letter via certified mail so I would have proof they received it. Then I posted about the incident on the Meadowbrook Heights Facebook group, which was an unofficial page where residents complained about HOA issues. Within an hour, I had dozens of comments from neighbors sharing their own horror stories about HOA negligence and the management company's refusal to take responsibility for problems. One neighbor, a woman named Jennifer, sent me a private message. "Peter, I went through something similar last year when the HOA's tree trimming company dropped a massive branch on my car. They denied responsibility for months until I got a lawyer involved. I'm happy to share my lawyer's contact information if you need it." I thanked her and saved the information. I was hoping it would not come to that, but I was starting to realize I might not have a choice. 3 days later, I received a response from the HOA. It was a form letter signed by Deborah Finch, stating that they had investigated the incident and determined that no HOA contractor was at fault for the damage described. The letter went on to say that homeowners are responsible for maintaining their own property and should file claims with their personal insurance for any damage that occurs. There was no mention of the video evidence I had told them about, no request to see the footage, no actual investigation that I could see, just a blanket denial. I called Deborah again. This time she sounded even more irritated to hear from me. "Mr. Rollins, you received our response. The matter is closed. You did not investigate anything. I have video evidence that shows your contractor destroying my property. We spoke with Superior Snow Services, and they have no record of any incident involving your property. Of course they do not, because the driver did not report it. That is why I am reporting it. And I have the video to prove it happened. Mr. Rollins, I do not have time for this. If you disagree with the board's decision, you can appeal it at the next board meeting in February. I already told you February is a month away. I need this resolved now. Then file a claim with your insurance. That is what it is there for. My insurance has a $1,000 deductible, and my rates will go up if I make a claim. Your contractor damaged my property. Why should I have to pay for that? This conversation is over. Do not call this office again unless you have a legitimate issue." She hung up on me again. I sat there staring at my phone, absolutely furious. This was deliberate stonewalling, and it was clear they had no intention of accepting responsibility. That evening, I called my homeowner's insurance company just to understand my options. The agent I spoke with was helpful but confirmed my fears. So if you file a claim, you would need to pay your deductible first, which is $1,000 according to your policy. We would send an adjuster out to assess the damage, and if the repair costs exceed your deductible, we would cover the rest. However, making a claim could affect your rates when your policy renews. What if the damage was caused by a third party? You can file a claim with us, and then we would subrogate against the responsible party. Basically, we would pay for your repairs and then go after them to recover our costs, but you would still be out your deductible unless we successfully recover it from them. And if they are refusing to accept responsibility, then we would have to decide if it is worth pursuing legal action. If they are really denying it, even with video evidence, it might end up in court. That is not a fast process. I thanked him and hung up. I was not going to file a claim with my insurance when I had clear evidence that the HOA's contractor was responsible. That felt like letting them get away with it. The next day, I edited together the video footage from all 3 camera angles, creating a clear, undeniable record of exactly what happened. The video showed the plow truck approaching, the blade angled wrong, the wave of snow and debris hitting my stairs, the destruction, and the driver looking back before driving away. I uploaded it to YouTube as an unlisted video so I could share the link. Then I sent another certified letter to the HOA board, this time including the YouTube link, and stating clearly that I had irrefutable video evidence. I gave them 5 more days to respond before I would pursue legal action. I also sent copies of all my documentation to Superior Snow Services, putting them on notice as well. While I waited, I started researching small claims court procedures in Illinois. The process seemed straightforward enough. I would file a complaint, pay the filing fee, serve the defendant with the court papers, and then we would have a hearing in front of a judge. The whole thing typically took 2 to 3 months from filing to judgment. I also got a few estimates for repairing the stairs. The lowest quote was $2,800. The highest was $3,500. I went with a local contractor who seemed reputable and could document everything properly for court. A week went by with no response from the HOA. Then, on a Tuesday morning, I got a call from a number I did not recognize. I answered, and a woman's voice said, "Hello, this is Patricia Murphy. I am president of the Meadowbrook Heights HOA board. I am calling about your complaint regarding the deck stairs." Finally, I thought, someone with actual authority. "Yes, thank you for calling. Did you receive the video evidence I sent?" "I did watch the video link you provided. However, I have concerns about the authenticity of the footage." I could not believe what I was hearing. "Concerns about authenticity? What are you talking about? It is raw footage from my security cameras with timestamps." "Well, anyone can edit video these days, and the angle makes it difficult to see exactly what happened. There are 3 different angles. You can clearly see the plow hitting the stairs and destroying them. The license plate is visible. The company logo is visible. Everything is clear as day. Mr. Rollins, I understand you are upset about damage to your property, but making false claims against the HOA is a serious matter. It could even be grounds for fines or other disciplinary action under our covenant rules." My hands were shaking. I was so angry. "Are you threatening me?" "I am simply explaining the consequences of making unfounded accusations. Now, the board has reviewed your complaint and our position remains the same. We are not responsible for your deck stairs. If you insist on pursuing this matter, you will need to go through proper legal channels." "That is exactly what I am going to do. That is your right. But I should warn you that the HOA has legal representation on retainer, and we will vigorously defend against any frivolous lawsuits. You might want to consider whether the cost of litigation is really worth it for a few $1,000s in damage. It is not about the money. It is about the principle. Your contractor destroyed my property and you are all lying about it. Good luck, Mr. Rollins. I suspect you are going to need it." She hung up. I sat there for a moment, then I called Jennifer, the neighbor who had offered her lawyer's contact information. She answered on the 3rd ring. "Jennifer, this is Peter Rollins. I think I need that lawyer's number you mentioned." "That bad, huh? They are denying everything even though I have video evidence. The board president basically threatened me with HOA fines if I keep pushing." "Yeah, that sounds like Patricia. She is the worst. Hang on, let me find that number." She texted me the information for an attorney named Marcus Hayes who apparently specialized in HOA disputes. I called his office and explained the situation to his paralegal, who scheduled me for a consultation later that week. Attorney Hayes turned out to be a man in his mid-50s with gray hair and a no-nonsense demeanor. His office was in downtown Naperville in one of the older brick buildings near the courthouse. I showed him all my documentation, the videos, the letters, the police report, everything. He watched the video footage carefully, then leaned back in his chair. "Mr. Rollins, you have an excellent case. This is about as clear-cut as it gets. The video evidence is damning. Any reasonable person watching this would see exactly what happened. So why are they fighting it? Because HOAs operate with a certain degree of arrogance. They are used to bullying homeowners into submission. Most people do not want the hassle of fighting back, so they just pay for repairs themselves and move on. The HOA is counting on you to do the same thing." "I am not going to." "Good. Here is what I recommend. Small claims court is an option, but based on your repair estimates, you are right at the limit. If there are any additional costs or complications, you could exceed the small claims threshold. Also, small claims court in Illinois does not allow attorneys to represent parties, so I could not appear with you." I thought about that, but I have all the evidence. It seems pretty straightforward. It should be. But here is the thing. If you file in small claims and win, you will get a judgment for your damages. However, the HOA might still refuse to pay, and then you would have to try to collect on that judgment, which is a whole other hassle. If I represent you and we file in circuit court instead, we can also seek attorney's fees and court costs under Illinois law. The threat of having to pay your legal bills on top of the damages might motivate them to settle. What would your fees be? For something like this, I would typically charge a flat fee of around $3,000 to handle the case through settlement or trial. But given the strength of your evidence and the fact that we can seek attorney's fees, I am willing to take this on a contingency basis. If we win or settle, I take 1/3 of the total recovery. If we lose, you pay nothing. And you think we can win based on what you have shown me? Absolutely. The video is ironclad. They have no defense. The question is whether they will keep fighting out of stubbornness or whether they will see reason and settle. I thought about it. Having a lawyer handle everything would certainly be less stressful than doing it myself in small claims court. And if Hayes was confident enough to take it on contingency, that said something about the strength of the case. Okay, let's do it. We signed a retainer agreement, and Hayes said he would get started on drafting a complaint immediately. I am going to name both the HOA and Superior Snow Services as defendants. That way, they cannot point fingers at each other. We will let them figure out between themselves who pays, but one of them is going to be responsible. Over the next 2 weeks, Hayes put together the legal complaint. It was impressive how thorough it was, laying out every detail of what happened, the HOA's refusal to accept responsibility, my attempts to resolve the matter, and the clear video evidence. We were suing for the cost of repairs, which was $2,800, plus emotional distress, loss of use of the property, and attorney's fees. The complaint was filed with the DuPage County Circuit Court on February 10th. A few days later, the HOA and Superior Snow Services were served with the lawsuit. I half expected them to ignore it, but Hayes assured me they would have to respond or face a default judgment. About a week after being served, I got a call from Patricia Murphy again. She sounded much less confident than before. "Mr. Rollins, I received notice of your lawsuit. This really is not necessary. We can work this out." I tried to work it out. You accused me of faking video evidence and threatened to fine me. I think there may have been some miscommunication. The board is willing to reconsider your claim. Too late. This is in my lawyer's hands now. If you drop the lawsuit, we can discuss a settlement. Tell that to my attorney. His name is Marcus Hayes. I am sure you have his contact information from the court papers. I hung up. It felt good to finally have some leverage. A few days later, Hayes called me. "I just got off the phone with the HOA's attorney. They want to settle." "Really? Already?" "They know they cannot win. The video is too damning. They are offering to pay for your repairs plus $1,000 for your trouble." I thought about it. "What about your fees?" "They would pay those separately. So you would get the full repair costs plus the $1,000 and they would pay me directly." "How much are they offering to pay you?" "They are proposing $2,500 for attorney's fees. So I would be whole on the repairs, get $1,000 and you would get $2,500. That seems almost too easy." "It is a reasonable offer, but here is the thing. If we go to trial and win, which I am very confident we would, we could potentially get more. We could argue for higher damages, more money for your inconvenience, and full attorney's fees based on my actual time invested, which could be more than $2,500 depending on how much they fight. But that means going through discovery, depositions, possibly a trial which could take 6 months or more. What do you think I should do?" "Honestly, I think we should counter. You have them on the ropes." Let's ask for the repair costs, $3,000 for your trouble and $5,000 for attorney's fees. See if they bite. Do it. Hayes made the counter-offer. 2 days later, the HOA came back with a revised offer. Repair costs, $2,000 for me and $4,000 for attorney's fees. Hayes called me with the news. I think this is about as good as it is going to get without going to trial. You would net $2,000 on top of getting your stairs fixed, and they would pay me $4,000, which is more than my normal flat fee would have been. It is a solid outcome. I almost agreed. Then something in me balked. No, I want to go to trial. There was a pause on the other end of the line. Can I ask why? This is a good settlement. Because they lied to me. They threatened me. They accused me of faking evidence. I want a judge to see that video and tell them officially that they were wrong. I want it on the record. Hayes was quiet for a moment. I respect that. But I need to make sure you understand what you are signing up for. This could drag out for months. It will be stressful. And while I am confident we will win, there is never a 100% guarantee in court. I understand. Let's do it. All right then. I will let them know we are rejecting their settlement offer and proceeding to trial. The next few months were a blur of legal procedures. Discovery requests went back and forth. Hayes deposed the plow driver, a guy named Tommy who squirmed in his seat the entire time, and eventually admitted he might have misjudged the angle of his blade. Superior Snow Services owner tried to claim that their contract with the HOA specifically disclaimed liability for property damage. But Hayes pointed out that such disclaimers do not override basic negligence law. Patricia Murphy's deposition was particularly satisfying. Hayes grilled her about why the HOA never actually investigated the incident, why they accused me of faking video evidence without any basis, and why they threatened me with fines for filing a legitimate complaint. She had no good answers and grew increasingly flustered as the deposition went on. During this time, the destroyed stairs sat there as an eyesore. I could not use my back deck properly because the stairs were unsafe. I had to rope off the area to make sure no one accidentally got hurt. Every time I looked at them, I got angry all over again. The trial was finally scheduled for August 20th. As the date approached, Hayes and I met several times to prepare. He walked me through what to expect, what questions he would ask me, what the defense might try to argue. He seemed more confident than ever. They are going to try to argue that the damage could have been caused by something else, or that the video does not clearly show their driver was negligent. But I have watched that footage 100 times now. There is no ambiguity. The driver was going too fast, had his blade angled wrong, and created the wave of snow that destroyed your stairs. Any reasonable person can see that. The night before the trial, I barely slept. Sarah tried to reassure me. You have the truth on your side. The video does not lie. You are going to be fine. I arrived at the DuPage County Courthouse at 8 in the morning. Hayes met me in the lobby looking sharp in a dark suit. Ready as I will ever be. We went through security and made our way to the courtroom. It was smaller than I expected, more like a large conference room than the dramatic courtrooms you see on television. The judge's bench was at the front, with tables for each side facing it. There was a small gallery of seats in the back. Patricia Murphy was there with the HOA's attorney, a stern-looking woman named Carol Henderson. The owner of Superior Snow Services, Mike, was also there with his own lawyer. They all looked uncomfortable. The judge, a man named Thomas Warner, entered at 9 sharp. We all stood, then sat back down as he settled into his chair. He was probably in his early 60s, with reading glasses and a no-nonsense expression. Good morning. This is case number 2026 L543, Rollins versus Meadowbrook Heights Homeowners Association and Superior Snow Services. Are both parties ready to proceed? Hayes stood. Yes, Your Honor. Henderson stood as well. Yes, Your Honor, the judge nodded. This is a bench trial, so I will be acting as both judge and jury. Mr. Hayes, as the plaintiff's counsel, you may give your opening statement. Hayes stood and walked to a position where he could address the judge clearly. Your Honor, this is a simple case about responsibility and accountability. On the morning of January 15, 2026, a snowplow driver employed by Superior Snow Services, working under contract for the Meadowbrook Heights HOA, drove recklessly through my client's neighborhood and destroyed property belonging to Mr. Rollins. The driver saw what he had done and fled without reporting it. When Mr. Rollins reported the incident to the HOA, they denied responsibility, accused him of fabricating evidence, and threatened him with fines for making a legitimate complaint. We have video evidence from 3 different angles that clearly shows what happened. This is not a he said, she said situation. This is not a matter of interpretation. The video speaks for itself, and it will prove beyond any doubt that the defendants are liable for the damage to Mr. Rollins' property. Henderson gave her opening statement next, arguing that the video was not as clear as we claimed, that winter snow removal necessarily involves some risk of incidental property damage, and that homeowners assume that risk when they live in a community with snow removal services. It was a weak argument, and I could tell the judge was not impressed. Hayes called me to the stand first. I swore to tell the truth and sat down. He walked me through the events of that morning, asking me to describe exactly what I saw when I saw it and what I did afterward. I explained how I had immediately called the HOA, how Deborah Finch dismissed my complaint, how Patricia Murphy accused me of faking the video. Mr. Rollins, what was your emotional state when the HOA accused you of fabricating evidence? I was furious and hurt, honestly. I had been trying to do everything the right way, following their procedures, and they just treated me like I was some kind of criminal. It felt like they cared more about avoiding responsibility than about actually resolving the problem. And did you, in fact, fabricate or alter that video evidence in any way? Absolutely not. It is raw footage from my security cameras. Henderson cross-examined me, trying to suggest that I might have been mistaken about what I saw, that maybe the stairs were already damaged before the plow came through. It was a ridiculous line of questioning, and I calmly refuted every suggestion. Then Hayes played the video evidence. He had brought a laptop and connected it to a large monitor that the court provided. The judge leaned forward in his seat, watching intently as the footage played from all 3 angles. The courtroom was completely silent except for the sound of the video. You could see everything. The plow approaching too fast, the blade angled wrong, the wave of snow and debris, the impact, the destruction, the driver looking back. It was undeniable. When the video finished, Judge Warner sat back in his chair. Mr. Hayes, can you play that again, please? Hayes played it a second time. The judge watched just as carefully. When it finished, he looked at Henderson. Counselor, do you dispute that this video shows your client's plow striking the plaintiff's stairs? Henderson stood. Your Honor, we would argue that the video does not clearly establish that our driver was negligent. Snow removal operations necessarily involve significant force, and some incidental property damage is an unavoidable consequence. The driver was looking where he was going, was he not? Yes, Your Honor. And the stairs were clearly visible. I suppose so, but in heavy snow conditions, visibility can be, Counselor, I can see the video. The sun is up. Visibility is fine. The stairs are right there. The driver plowed directly into them. He turned to the lawyer for superior snow services. "You have anything to add?" The lawyer, a young man who looked fresh out of law school, stood nervously. "Your Honor, our position is that if there was negligence, it was the fault of the individual driver, not the company. We provide extensive training to all our operators." "And who employs this driver?" "We do, Your Honor, but then you are liable for his actions while he was working for you. That is basic respondit superior." Hayes called a few more witnesses, including the contractor who had given me the repair estimate, and a neighbor who testified that he had also seen the plow driving recklessly that morning. Then he rested his case. Henderson put Patricia Murphy on the stand. Hayes cross-examined her, and it was brutal. He pulled out the letters she had sent me, the ones denying responsibility and threatening fines. "Mrs. Murphy, in this letter dated January 25th, you stated that you had concerns about the authenticity of Mr. Rollins' video evidence. What were those concerns based on?" Patricia looked uncomfortable. "Well, I thought the video might have been edited." "Did you have any evidence that it was edited?" "No, but you never know these days." "Did you hire a video forensics expert to analyze the footage?" "No." "Did you ask Mr. Rollins to provide the raw files from his security system?" "No." "So you accused him of fabricating evidence based on nothing but your own speculation." "I was just being cautious." "Were you being cautious, or were you trying to avoid responsibility?" "Objection," Henderson said. "Argumentative." "Sustained," the judge said, but I could see the point had been made. Hayes continued. "Mrs. Murphy, in your phone call with Mr. Rollins on January 30th, you told him that making false claims against the HOA could be grounds for fines." "Is that correct?" "I may have said something like that." "Why would you threaten a homeowner with fines for reporting property damage?" "I was not threatening him. I was just explaining the rules." "What rule specifically prohibits homeowners from filing legitimate complaints?" Patricia did not have a good answer. She stammered for a moment, then said, "I was trying to discourage frivolous complaints." "But his complaint was not frivolous, was it? As we have seen from the video evidence, the plow really did destroy his stairs." "I suppose so." "So you threatened him with fines for filing a legitimate complaint that turned out to be absolutely true?" I may have handled it poorly." When Patricia stepped down, she looked defeated. The judge called for closing arguments. Hayes was concise and effective. "Your Honor, the evidence is overwhelming. The video clearly shows the defendant's plow driver destroying Mr. Rollins' property through careless operation of his vehicle. The HOA and the snow removal company both failed to take responsibility, instead choosing to deny the obvious truth and attack the victim. Mr. Rollins is entitled to compensation for his repair costs, for his time and trouble, and for the emotional distress caused by the defendant's bad faith refusal to make things right. We ask the court to award full damages plus attorney's fees." Henderson argued that the damage was an unfortunate accident, that the HOA had acted in good faith, and that awarding attorney's fees would be inappropriate. It was a weak closing that did not address any of the actual evidence. Judge Warner took off his glasses and looked at both sides. "I will be honest with you. This is one of the clearer cases I have seen in a long time. The video evidence is indisputable. The plow driver was operating negligently, and his negligence directly caused significant damage to Mr. Rollins' property. That alone would be sufficient to fine for the plaintiff." He turned to look directly at Patricia and the HOA's lawyer. "But what makes this case particularly egregious is the conduct of the HOA after the incident. Mr. Rollins did everything right. He reported the problem immediately, he provided clear evidence, and he tried to work through the proper channels. Instead of investigating his complaint fairly, the HOA immediately went into denial mode. They accused him of fabricating evidence without any basis. They threatened him with fines for making a legitimate complaint. They forced him to hire an attorney and file a lawsuit just to get basic accountability for obvious damage. The judge put his glasses back on and looked at his notes. I find in favor of the plaintiff, Peter Rollins. The defendants, Meadowbrook Heights Homeowners Association and Superior Snow Services, are jointly and severally liable for the following damages: $2,800 for repair costs, $3,000 for emotional distress and loss of use of property, and $5,000 for attorney's fees and court costs. Total judgment is $10,800. I felt a wave of relief wash over me. Hayes reached over and shook my hand. Behind me, I could hear Patricia and the lawyers whispering urgently. The judge was not done. Furthermore, I am troubled by the HOA's conduct in this matter. Mrs. Murphy, you are the president of this board. Patricia stood. Yes, Your Honor. Let me be very clear. Homeowner associations exist to serve the residents of their communities, not to bully them. The way you treated Mr. Rollins was unacceptable. You accused him of fraud with no evidence. You threatened him with punishment for filing a legitimate complaint. That is not leadership. That is abuse of power. I strongly encourage the residents of Meadowbrook Heights to consider whether their current board is serving their interests. Patricia sat down, her face bright red. The judge banged his gavel. This court is adjourned. As we left the courtroom, several reporters from local papers approached us. Apparently, someone had tipped them off that this was an interesting case. Hayes gave a brief statement about the importance of HOA accountability, and I just said I was glad justice had been done. Over the next few days, the story made the rounds in local media. The video of the plow destroying my stairs went viral on social media. People were outraged at how the HOA had treated me. The Meadowbrook Heights Facebook group exploded with residents calling for Patricia Murphy and the entire board to resign. True to form, the HOA tried to drag their feet on paying the judgment. Hayes had to file a motion to compel payment, and eventually they sent a check for the full amount. I got my $3,000 plus the repair costs. Hayes got his $5,000, and my deck stairs got rebuilt, this time even better than before. But the story does not end there. About 3 weeks after the trial, I got a call from a woman named Amanda Sheffield who lived a few streets over from me. Mr. Rollins, I do not know if you remember me, but we met briefly at a neighborhood barbecue last summer. I wanted to thank you for fighting the HOA. You are welcome, but I was really just fighting for myself. Maybe, but you have inspired a lot of us. A group of homeowners are organizing a recall petition for the entire board. We have had enough of Patricia Murphy and her cronies. Would you be willing to support the effort? I thought about it. Part of me wanted to just put this whole ordeal behind me and move on. But another part of me remembered how Patricia had tried to intimidate me, how the board had circled the wagons to avoid responsibility, how they had treated a legitimate complaint as if it was some kind of personal attack. Yes, I will support it. What do you need? Over the next month, Amanda and several other residents worked tirelessly to gather signatures for the recall. According to the HOA bylaws, 25% of homeowners could petition for a special election to recall board members. We got 35%. The special election was scheduled for October 15th. Patricia Murphy and the other board members tried to campaign to keep their positions, but they had no credibility left. The story of what they had done to me had become well known throughout the community. The video had been viewed hundreds of thousands of times online. They were a laughingstock. On election day, Sarah and I went to vote at the community center. The turnout was massive, far higher than typical HOA elections. When the results were announced that evening, Patricia Murphy and the entire board had been voted out by overwhelming margins. Amanda Sheffield was elected as the new board president, along with several other reform-minded candidates. One of the first actions of the new board was to terminate the contract with the management company that employed Deborah Finch. They hired a new company that had a reputation for actually serving homeowners instead of treating them as adversaries. They also implemented new policies requiring transparent investigation of resident complaints and forbidding board members from threatening residents with fines for filing legitimate concerns. In December, almost a year after the whole ordeal began, I got a handwritten note in the mail from Amanda. "Peter, I wanted to thank you again for standing up to the old board. Your courage made a real difference in our community. The new board is working hard to undo years of bad policies and rebuild trust with residents. We could not have done it without you. If you ever need anything, please do not hesitate to reach out." I showed the note to Sarah that evening as we sat on our newly rebuilt deck. Snow was falling again, the first decent accumulation of the winter. But this time, when I heard the sound of a plow truck approaching, I did not tense up. The new snow removal company that the board had hired was professional and careful. I watched as the driver slowly and methodically cleared our street, making sure to keep his blade angled properly to avoid any property damage. "Was it worth it?" Sarah asked, sipping her hot chocolate. I thought about everything we had been through. The frustration, the stress, the months of legal battles, the time and energy it had all consumed. Then I thought about Patricia Murphy's face in the courtroom when the judge delivered his verdict. I thought about Amanda's note and the positive changes that were happening in the community. "Yeah," I said, "it was worth it. The whole experience taught me something important about standing up for yourself. It would have been easier to just file a claim with my insurance and eat the deductible. It would have been easier to accept the settlement offer and move on. It would have been easier to let the HOA bully me into silence. But sometimes the right thing to do is not the easy thing. Sometimes you have to fight for the principle, not just the money. Sometimes you have to stand up to people who abuse their power, even when it is inconvenient and stressful." I never would have guessed that a snowplow destroying my deck stairs would lead to a complete transformation of our HOA, but that is exactly what happened. One act of negligence, one refusal to take responsibility, one homeowner who decided to fight back, and everything changed. The security cameras that captured the incident are still there, still recording. I review the footage occasionally, not because I enjoy reliving the experience, but because it reminds me of what is possible when you refuse to back down from the truth. The video does not lie. The evidence does not lie. And when you have truth on your side, justice is possible. My deck stairs are beautiful now, rebuilt with even higher quality materials than before. Every time I use them, I think about the journey it took to get them fixed properly. Every time I see Patricia Murphy around the neighborhood, which is rare these days because she mostly keeps to herself now, I remember that accountability matters. The HOA still exists, of course. It always will as long as covenants are attached to our properties. But it is different now. The new board actually responds to residents. They investigate complaints fairly. They take responsibility when contractors make mistakes. They treat homeowners like customers rather than subjects. And me. I am just a software developer who wanted his deck stairs fixed. I never set out to become some kind of HOA reform activist. I just wanted people to take responsibility for their actions. I just wanted the truth to matter. I just wanted justice. I got all three, and I helped change a community in the process. Not bad for a guy who just wanted to drink his morning coffee in peace. Looking back now, more than a year later, I can see how the whole situation could have gone differently at so many points. If the plow driver had just stopped and reported what happened, his insurance would have handled it, and that would have been the end of it. If Deborah Finch had taken my complaint seriously, instead of dismissing it immediately, we could have resolved everything without drama. If Patricia Murphy had looked at the video evidence honestly instead of accusing me of fraud, we could have settled the matter quickly and reasonably. But they made their choices, and those choices had consequences. The plow driver lost his job when the story went viral. Deborah Finch was fired when the new board terminated the management company's contract. Patricia Murphy became a pariah in the community she had tried to rule over. Superior Snow Services lost the HOA contract, and several other clients who saw the video. Meanwhile, I got my stairs fixed, won my court case, helped elect a better board, and improved life for everyone in Meadowbrook Heights. Sometimes being stubborn pays off. Sarah jokes that I should write a book about the experience, maybe call it How to Fight Your HOA and Win, or something like that. I'm not sure anyone would want to read an entire book about deck stairs and homeowner association politics, but the story has certainly resonated with people online. The YouTube video of the incident has over 2 million views now, and I get messages regularly from people dealing with their own HOA nightmares, asking for advice. My advice is always the same: document everything. Get evidence. Know your rights. Do not be afraid to stand up for yourself. And if you have video proof that you are right, do not let anyone gaslight you into thinking you are wrong. The experience also taught me something about community. Before this happened, I barely knew any of my neighbors. We would wave in passing, maybe chat briefly about the weather, but that was it. Now, after the recall election and all the drama, I have real friendships with people in the neighborhood. Amanda and her husband come over for dinner regularly. Jennifer, who gave me my lawyer's number, is one of Sarah's closest friends now. We have a whole group of neighbors who get together monthly for game nights. In a weird way, Patricia Murphy's terrible leadership brought the community together. We all had stories about how the old board had treated us poorly. We all had complaints that had been dismissed or ignored. By fighting back against it, by demanding better, we found common cause with each other. The new HOA board actually listens to residents now. They hold monthly town halls where anyone can speak. They publish financial reports so we can see where our dues are going. They hire contractors based on quality and reliability, not just whoever bids the lowest. They treat mistakes as problems to be solved, not accusations to be denied. It is not perfect. No HOA ever will be. There are still rules that some people think are too strict and others think are not strict enough. There are still disputes about things like fence heights and paint colors. But at least now there is a process that feels fair. At least now residents feel heard. As for my security cameras, they are still running. I upgraded to a newer system with even better resolution and night vision. Not because I am paranoid, but because I learned the value of having objective evidence when disputes arise. Several of my neighbors have installed similar systems now. Ironically, the cameras have been useful for reasons that have nothing to do with the HOA. They helped the police identify a package thief who was hitting our neighborhood last summer. They captured footage of a hit-and-run accident that helped a neighbor file an insurance claim. They even recorded a meteor shower last fall that was pretty spectacular. But mostly, they just record the mundane rhythms of suburban life. Squirrels running across the yard. Kids riding bikes on the street. snowplows driving by carefully and professionally, doing their jobs without destroying anyone's property. That is how it should be. Normal, boring, uneventful. I never wanted my 15 minutes of fame. I never wanted to become the face of HOA reform in DuPage County. I just wanted my deck stairs fixed. But sometimes life takes you places you did not expect, and you have to decide whether to go along for the ride or get off early. I am glad I stayed on. I am glad I fought. I am glad I did not let them get away with it. And I am especially glad that I had those security cameras rolling on the morning of January 15th, 2026, because without that video evidence, none of this would have been possible. Patricia Murphy and the board would have gotten away with their denial and cover-up. I would have been out thousands of dollars. The community would still be suffering under terrible leadership. One video, one moment of truth, one person willing to fight. That is all it took to change everything. As I sit here now, writing this all down, I can see my deck stairs through the window. They look great. They are solid, properly built, up to code, and they lead to a deck where Sarah and I spend summer evenings grilling and enjoying the weather. Those stairs represent more than just a way to get from point A to point B. They represent justice. They represent accountability. They represent the idea that truth matters and people should take responsibility for their actions. The whole experience cost me time, stress, and energy. But it gave me something more valuable. The knowledge that standing up for yourself is worth it. That fighting for what is right, even when it is hard, even when people try to intimidate you, even when it would be easier to just give up, is worth it. If I could go back to that morning in January and somehow prevent the plow from hitting my stairs, would I do it? Of course. It would save a lot of hassle. But since I cannot change what happened, I am at least grateful that good came out of it. A better HOA, a stronger community, friendships formed through shared adversity, and hopefully, one fewer HOA board president who thinks they can lie their way out of responsibility when video evidence proves them wrong. So that is my story. That is how a snowplow destroying my deck stairs turned into a year-long saga involving lawsuits, board recalls, viral videos, and community transformation. It is not the story I expected to live, but it is the one I got, and I would not change how it turned out. Well, except maybe I would have built the stairs a little further from the street. But hindsight is always clearer than foresight, and at least I got a good story out of it.